Welcome to the Probate Nation. My name is Ruddy, and I'm the host of the show this evening. People are living longer thanks to good health care and healthy lifestyles. But as we age, not everyone remains as sharp as they were years ago. And frequently, an adult child is called upon to take on the responsibility of helping their elderly parent with financial and medical decisions. We have discussed in past shows how the execution of a durable power of attorney and advanced medical directive can empower you to provide that help. But not everyone executes those documents. So when the time comes for you to help your elderly parent, you may need to take formal legal steps to get appointed to serve as their conservator and guardian. The process to be appointed to those positions is like a carefully choreographed play with many actors who have very specific roles to play in the process. That process begins with the filing with the court of a formal petition seeking to be appointed guardian or conservator. The person filing that petition is called the petitioner. The person who the petitioner wants to be guardian and conservator of, typically their parent, is referred to as the respondent. And on filing the petition, another participant called the guardian ad litem, or GAL, comes on the stage as well. And of course, joining these participants as this play unfolds are their attorneys, experts, and various circuit court judges. In an earlier show on this topic, we sorted through some of the initial questions about the GAL, including who can be a GAL, how they are appointed, the role of the GAL, and the type of GAL investigation that is done. In our show this evening, we continue to sort through further questions about the GAL as the petition progresses through the litigation process. We are pleased to have back with us the guest from our initial show on this subject. Our first guest is an attorney who handles guardianships, conservatorships, wills, trusts, and estates. She practices throughout Northern Virginia, the Valley, and the Northern Neck, and also serves as a guardian ad litem in those areas. She is the past president of the Virginia Women's Attorneys Association. Prior to returning to private practice, she worked at the United States Treasury Department and 2 financial institutions. Our second guest is a prominent Arlington attorney in private practice who specializes in estate, trust, probate, and guardianship matters. He speaks regularly at continuing legal education programs on adult guardianship and conservatorship, and has previously served 2 terms as president of the Arlington County Bar Association. Please join me in welcoming back attorneys Betsy Sue Scott and George Dodge. Guys, welcome back.
Thank you, Richard.
We learned a lot during that first show, but boy, we have so much more to cover. So we need to get right into it. So Betsy Sue, let's talk about the attorney representing the respondent. Okay, so what is the role of the attorney when they represent the respondent?
In that case, the attorney is the actual representative, legal representative for the respondent, has filed a notice of appearance, and will represent for all purposes the respondent during the lawsuit, the legal proceeding, if you will.
Okay, so we talked about one of the things that we talk about, and when the GAL goes to visit the respondent is let them know they have a right to have an attorney represent them. So what are the options if the attorney wishes to, if the respondent wants to have their own attorney, what are their options to obtain such an attorney?
If the respondent has the ability to research an attorney, knows an attorney, can get online, talk to neighbors, talk to friends, and make the telephone call, then the respondent can hire his or her own attorney. If there are challenges, some type of impairment, and the GAL believes that respondent has a need for his or her interest to be protected in a pure advocacy mode by an attorney, then the GAL can notify the court. It's one of the, again, statutory duties to recommend to the court that legal counsel be appointed. And that would come in form typically of a motion to appoint legal counsel.
Okay, okay. So George, let's and I guess we talked a little bit about that. If the person does not have the money to hire their own attorney, yes, which we'll talk about a little bit more, then the Commonwealth of Virginia will actually pick up the costs. Right. So if someone wants an attorney or needs an attorney and doesn't have the money, we will get them a lawyer.
Right, and that would be part of the recommendation of the GAL. It would be included in the appointment order typically, but that would be covered, and as you point out, the fee would be paid. Everyone wants to ensure that there's access to justice for everybody.
And that's very, very important. George, let's turn to the actual, all this work we're doing, okay, going to eventually be reduced to a report by the GAL to the court, again, as the eyes and ears of the court, as we've talked about. So what do we do with all the information we've gathered?
Well, it's required that the guardian ad litem write a report and file it with the court and with the other attorneys involved. And it's to include a variety of things that are mandated in the statute, such as, does this court have jurisdiction over the case? Then does the person lack capacity? That needs to be addressed. And also the levels of incapacity, in case you're looking at recommendations for a limited guardianship or conservator. Then who is suitable? Who are you recommending as the guardian or conservator? Who should serve? That information needs to be in the report. Then there's also you have to ascertain the assets, because the court is going to want to know what is your recommendation as to bond. And if I could take a moment to mention a couple of different things about the bond. If you're guardian, there's a personal bond, normally of $1,000, to set in the order to guarantee the faithful performance of that person's duties. However, for conservatorship, you have to present to the court the total assets, and those assets have to be covered in a bond with an insurance company, again, to warrant the faithful performance of the duties of the conservator. So you are the one to investigate and tell the court that, and that's a very important aspect of this as well. So you've got these recommendations that you're putting in your report, as well as sometimes the preferences of the respondent. If it looks like there might be a placement, they need to express what their thoughts are about certain, what their placement needs are. So these all need to come in the report and should give the judge an entire view within the limited scope of this guardianship petition as to cover all these issues that again, you're required to present to the court.
Now, in preparing that report, though, you have kind of conversation early on with petitioner's counsel to figure out find out whether this is going to be a contested hearing or an uncontested hearing. Does that have an impact as to what goes into the report?
You still need to address these issues, and a judge is going to get the report and read it before court, and it's placed on what we sometimes refer to as the consent docket. And it's a key document for that particular docket, because the only other documents that a judge will have available to him or her are the capacity evaluation and maybe some attachments to the petition and the petition itself. So it's key in the review process and in this overall decision-making process.
So that is definitely important if it's an uncontested hearing. But
Correct.
if it's a contested hearing, then the judge probably would not be able to look at that because it's going to be considered hearsay, right?
That is correct. So it does serve a purpose, though, for the guardian ad litem. It's an opening statement for them as to the direction they think the case is going to go. And their recommendations will probably still be valid. But again, during the course of a trial, I think a guardian ad litem is entitled to change their mind based on evidence that might come out at trial that they didn't hear about or learn about during their investigation.
Okay.
And Richard, if I may add just one thing to George's comments, that when it's going to be a contested guardianship, conservatorship, the GAL will likely recommend to the court that counsel be appointed, so that one thing that a GAL may do is file a preliminary GAL report and give the judge as much of the information that has been adduced at that point. We're going into a contested matter, Your Honor. Here is what we know, and please appoint counsel to actually advocate and provide legal representation at that stage.
That's a good point. That's a way to sort of bring to a conclusion, basically, I think, their service at that particular point.
Yes.
And at that point, counsel take over the advocacy role and go through the normal discovery process to get us to a hearing in a contested matter. Very good point, Betsy Sue. But as a practical matter, George, aren't most of these petitions uncontested?
Most are, but every case is unique, and there are a handful that are tried. And again, I think the system wouldn't work if there were even more contested cases, but by and large, I would say maybe 90% or more are on the consent docket.
Sure. And the consent docket varies by jurisdiction, but everyone has a consent docket to deal with these things.
Yes.
Okay. Well, Betsy Sue, let's talk about the uncontested hearing in court. What happens in an uncontested hearing?
At the uncontested hearing, the actual consideration by the court will take place. In other words, there will be a final decision whether to grant the relief requested, which is the appointment of a guardian conservator. And also we should throw in at this point something called a standby guardian and a standby conservator. And that would be an individual who would, at the final hearing for appointment, be designated as that type fiduciary to take office should the primary guardian, primary conservator no longer be able to serve. But the judge will call the case, and the petitioner's counsel, the petitioner, and the proposed guardian and conservator, if other than the petitioner, would be called forward. If the respondent is also present, and that's another issue, whether or not the respondent must attend, would all go forward with the GAL, appear before the judge, and the relief requested would be reviewed by the judge. And usually it could be a 5-minute proceeding. Bond would be set. As George mentioned, guardianship bond is usually just a personal bond without surety. And then if a conservator, hefty conservatorship bond might be assessed depending on the estate.
So these generally get handled pretty quickly.
Yes.
Now, one thing you mentioned, though, of course, if this actually is going to involve a conservatorship, you may get a court order entered, but you're not quite empowered yet. You have to go down to the probate office and get sworn in. And if you need a bond that is insured by an insurance company, you need to have made those arrangements in advance. Some folks, unfortunately, do not do that and find out they've got a court order, but they can't get the surety to insure the bond, which means they can't get it qualified, which means that their effort is for naught.
Exactly, and it would be something wise for GAL to ask early on, have you assured bond? And there have been proceedings, I'm sure George could speak to this as well, where halfway through a proceeding we find out that the proposed conservator is not bondable, and to go in for a motion for leave to amend petition. It's very troublesome not to have taken care of that step, and the GAL can help by asking that question early on in the proceeding.
That's an important thing to head off so we don't waste the time and money going through too far along.
And if I might just add one thing on the qualification,
Yes, ma'am.
that on the day of the hearing, it is good practice for the petitioners, of course, counsel to have made the appointment with the probate office, because there's a 30-day window for the fiduciary, the guardian conservator, to actually become qualified. If not, that opens a whole new issue.
And that's important to mention as well, that it varies by jurisdiction. Some jurisdictions do require you to make those arrangements in advance, whereas others have a process where they set that time aside to take care of those people that got appointed that morning and go ahead and get them qualified. So again, you need to think ahead and make those plans, because you may have a week or two lead time in order to get in there and get an appointment. Well, how about the records of the hearing? Are they sealed?
The record itself, there's no court reporter unless one has been requested. In an uncontested proceeding that's going to run perhaps 5 minutes, there is not an actual record of that. The petition is not sealed, and there's something called a confidential private addendum, which will have the respondent's social security number on it. That is sealed. And of course, the medical evaluation that we've discussed, that is filed under seal. That's statutory, and the clerk's office will place it in a separate location within the file at the time of filing the initial petition.
Okay, that's important to keep in mind. Those medical records, no matter when they come in, need to come under seal.
Exactly.
For confidentiality purposes.
Exactly.
Well, uncontested hearings seem to be fairly straightforward. Okay, we've all been in those, and then, each one's different, but they tend to go fairly smoothly. With some zigs and zags from time to time. But George, let's talk about the contested hearing. That's a free-for-all sometimes. What happens in the contested hearing? Kind of give us a perspective about what people can expect.
Well, the burden of proof is on the petitioner, and that means they have to prove that the respondent is incapacitated by a standard called clear and convincing evidence. Typically in a civil case, as we know, the standard is preponderance, just a little more than half. And of course, in a criminal case, it's a much higher standard, beyond a reasonable doubt. But this clear and convincing standard is somewhere in between those two. And again, the reason being is because the respondent is at risk of giving up rights if they're determined to be incapacitated. So that's where the petitioner has to start. And there might be medical evidence, anecdotal evidence, eyewitnesses might testify as to the conduct of the respondent that shows they can't make health care decisions or financial decisions. And it's not just a decision that you and I might not make, an occasional bad judgment. It has to be a continuous pattern that puts them at risk or shows some level of exploitation and that they're vulnerable to that. So that's where the evidence heads towards. And of course, the respondent and their lawyer has a chance to present their case later to rebut it. But you know, even if the respondent doesn't present any evidence, again, my main point is the petitioner has a big burden here. Clear and convincing is not a standard to be taken lightly.
Okay. Now, and how is the GAL report used in a contested hearing?
Well, it wouldn't be, because it would be deemed hearsay, but the guardian ad litem is to take an active role and cross-examine witnesses and can present their own witnesses in their goal of presenting what they believe is the best interest of that respondent. And it might overlap both sides sometimes, what they present.
How long does a contested hearing, and this is kind of a question that there's really probably no answer to, but how long does a contested hearing typically last?
I think in my experience, and I think from what I've heard in talking to Betsy Sue and other lawyers, is anywhere from a minimum of 2 hours to possibly 2 days. And that's assuming it's a non-jury trial. If it's a jury, of course, it could be longer because of the process of selecting a jury, and it just adds more time to a trial proceeding. But that's the relative range, I would say.
Okay. And of course, we talked about records being sealed in an uncontested manner. I think the same approach applies in a contested manner. The same types of records get sealed.
It can be done, yes.
Okay. Well, let's talk about contested hearings, uncontested hearings. These things don't happen for free. People are spending time, and there's costs associated with both filing and with people's time. So let's talk about who pays for the GAL. Is typically is an attorney. So who pays for the GAL? So Betsy Sue, if the respondent has financial resources, who pays for the GAL?
It's actually a roundabout answer, Richard.
Okay, unless you go.
The statute says that the petitioner shall pay the fees and costs as taxed by the court. Mm-hmm. And then there's another statute that sort of reallocates that duty and says that if the respondent has adequate resources and the court finds that the proceeding was brought in good faith for the benefit, then it moves the respondent's estate over to the one paying for the GAL's fee.
Okay. And of course, we talked a little bit, if it turns out that the respondent is declared to be indigent, okay, in the context of this particular area of the law, who pays for this GAL services?
The Commonwealth. Upon a finding of indigence by the court, the Commonwealth of Virginia.
Okay. So let's switch, George. Petitioners borne the cost to hire you to file a petition, and you tried the case, whether it's contested or uncontested. Who pays for your fees?
Well, the statute in Virginia that governs this allows for the recovery and reimbursement of costs and legal fees if a guardian and/or conservator is appointed. So that's an automatic payment once the judge reviews the timesheets and deems them as reasonable. That being said, the range of costs could go high if you have a 2 or 3 day contested trial. You're looking at thousands of dollars in attorney fees and costs. But there's also a provision that even if the petitioner loses and the respondent prevails in not having someone appointed as their guardian or conservator, a motion can be made to the court to show that this petition was brought in good faith, and the court can award fees nonetheless and assess them against the respondent. So even though they prevailed in court, they still might have to pay legal fees and costs. And these matters do get debated in court. So these are real issues that sometimes arise.
Sure. Okay. Well, that's important to know. And again, if it turns out that the respondent was indigent, the court could then award those fees to be paid by the Commonwealth.
They're paid by the Commonwealth at a set fee, that schedule that has been determined by the Virginia Supreme Court.
Okay. Okay. Well, we've covered a lot of things, and during the course of these two shows, we've identified a number of different challenges that the GAL faces. But I want to kind of bring that, kind of into one last section of this show and talk about bring out what are some of the common challenges that you see the GAL faces in doing their job, and how are these problems addressed? Betsy, you want to start with that?
One significant problem that comes up is where there is a desire of a person to continue driving. And
oh, yes.
That is,
my goodness.
it's right there. And the GAL will have done the research, investigated, consulted witnesses, usually the doctor, and come to a recommendation to the court that it's a safety issue to the individual and the public. So that is a significant challenge.
Okay. George, how about some problems you want to
I think the safety concern really overrides this whole guardianship process, and the deprivation of the right to own weapons is a real issue to people as well. That's the result of a finding of incapacity. The records are sent to Richmond, to the state police, and they are on the list of being unable to purchase and were required to give up their guns. I mean, it's a safety mechanism, and it's, again, it takes away a liberty that, just like driving privileges, voting privileges are sometimes taken away as well, depending on the person's aptitude. Not political party affiliation, but just aptitude.
Well, let's we've talked about so much, over the last two shows. I want to ask you, Betsy, to give me some final thoughts, things you want to really bring out in the final section of this show.
The guardian ad litem does serve as a privilege to serve the court, works very diligently to conduct an investigation, very detailed, listening to all these steps that George has outlined and we've discussed, and works to come to a recommendation to the court what he or she believes is in the best interest of the respondent. And that's important. That's what GAL does.
George, how about you? Some final thoughts about GAL?
I think during my tenure as an attorney, we've seen a major sea change in guardianship law. The reform bill went through effective January 1998. And since about that time, we've seen this specialization of elder law, guardianship, and I think the sensitivity of dealing with these delicate issues of the elderly and their impairments you can see it trickled down from the courts down to the training that guardian ad litems receive. With the courts, for example, we have special dockets in some jurisdictions so that a family or an incapacitated person does not have their business spread out in front of a full courtroom of other people. It's a early docket that's set just for those type of cases. So the courts have structured it that way, and the training and the ongoing training that attorneys receive shows this continued devotion to try to deal with this in a very professional and humane fashion.
Very well said. Well, again, I want to thank both of you for taking the time to visit with us, for sharing all your great information, and for this great public service you provided the folks across Northern Virginia. Thank you again.
Thank you.
Richard.
There's much that needs to be done to successfully prosecute a petition for conservatorship and guardianship for your elderly parent. A key contributor to that process is the court-appointed guardian Litem. In this show, we completed our conversation about the role of a GAL in these types of legal proceedings and addressed, should an attorney be hired to represent the respondent? Talked about the importance of the GAL and his report to the court in both an uncontested and contested hearing. We also talked about who pays the fees for both the GAL and the attorney who represents the petitioner, and common problems the GAL faces. This brings us to the conclusion of our show today on guardian, Litem, and adult conservatorship and guardianship cases. Hope you found it informative. And remember that replays of this show and the earlier show on this topic can be viewed on the Probate Nation website. On behalf of the Probate Nation, thank you for visiting with us.